Hi everyone, thank you so much for joining us for today's free webinar, Immigration Challenges for Startups and Emerging Businesses, with Delia Ghosh from Barry Appelman and Leiden LLP. My name is Erica Malsberg and I'm the Chief Marketing Officer for Early Growth Financial Services, and I'm going to be your moderator today. This presentation is going to run about 40 minutes or so. If you have questions as we go along, please feel free to enter them right into the question field, or you can also tweet them to us at earlygrowthfs with the hashtag StartupImmigration. Don't just raise your hand, just go right ahead and enter in those questions so that we can see them. Because the topic here is of legal issues, it's on a real case-by-case basis, and we may not be able to answer all your questions specifically. So if you have follow-up questions after, feel free to reach out to Delia. Her contact information will be in the last slide. And we'll be mailing this deck to you guys tomorrow along with the recording, so you'll have that information for your reference. So I want to start by introducing Delia. Delia Ghosh is a partner in the San Francisco office of Barry Appelman and Leiden LLP, to which she brings a wide range of corporate and family-based immigration experience. She represents clients of all sizes in industries such as financial services, biotech, retail, and technology. She provides strategic counsel on all aspects of corporate immigration law and compliance, including non-immigrant visas, permanent residence, naturalization, I-9 and LCA compliance, and corporate restructuring. Delia's prior experience includes handling employment-based and family-based U.S. immigration matters for large global immigration law firm and a boutique immigration law firm. She is an active member of the American Immigration Lawyers Association as well. So hello and welcome to you, Delia.
Hi, thank you so much for having me.
Of course, our pleasure. So before we jump into the content, I'm just going to give you a few words to say a little bit about Barry Appelman and Leiden, and I'd like to say a few words about early growth as well.
Okay, well, BAL, or Barry Appelman and Leiden, is a full-service corporate immigration firm, and we have approximately 500 employees located in offices in the United States and around the world. We represent corporate clients of varying sizes in a multitude of industries.
Great. And just to say a few words about us, many of you are probably familiar with us, but we're Early Growth Financial Services. So what we do is we're an outsourced financial services firm that provides accounting, strategic finance, CFO services, tax, and valuation services and support to small to mid-sized companies at all stages of the development process. We're currently operating in 9 markets from Silicon Valley to New York City and have about 475 active clients right now, including TechShop, Indiegogo, Ouya, Zendesk, Cloud, RocketSpace, and so many more. If you're interested in learning more about us, you can go check out our website. And if you think it'd be useful, we offer a free 30-minute financial consultation, so you can fill out a form for that. That said, why don't you go ahead, Delia, and give a little overview of what we're going to be talking about today.
Okay, today we are going to be covering the agencies that you deal with when you deal with U.S. immigration and some basic concepts that may be helpful when you are touching upon U.S. immigration. We're going to be talking about common non-immigrant and immigrant visas and the differences between those, as well as challenges that startups in particular face for both of these different categories. And finally, we're going to just touch on some special considerations for founders and owners of businesses.
Great, thanks. So let's start with the background, the foundation here. So who are the relevant agencies that we're talking about when it comes to immigration?
Okay. All right. So when you think of immigration, most people typically think about the Immigration Service, or it used to be called the INS, Immigration and Naturalization Service. It's now called the U.S. Citizenship and Immigration Service, or USCIS. But in reality, when you deal with U.S. immigration, you are actually dealing with multiple federal agencies. And the primary federal agency that you deal with is the Department of Homeland Security, which houses the USCIS, Customs and Border Protection, which are your ports of entry, as well as ICE, or Immigration and Customs Enforcement. And those are the people who do the raids and the audits. Now, in addition to DHS, you also deal with the Department of Labor, which is ultimately responsible for protecting the U.S. worker and U.S. worker wages. And finally, we also have to work with consulates and U.S. embassies, and that is because that's where people apply for their visa stamps in order to enter the United States. So you're dealing with multiple agencies. You just hear about the Immigration Service more often than the other ones.
Okay, great. And here those acronyms are starting to come in, right? Delia already warned me that there's so many acronyms when it comes to law. So she's going to be mindful of spelling them out for some of us lay people who may not be familiar with them. And I will ask her to clarify if I don't know, and feel free to jump in if you guys need some clarification as well. So that said, let's talk about these key immigration concepts. Can you tell us a little bit about that?
Okay. The most basic concept that you probably want to be aware of if you're ever going to deal with immigration is the difference between non-immigrant and immigrant. And non-immigrant visas or non-immigrant individuals are individuals who are coming to the U.S. temporarily for a finite period of time, whereas immigrants are people who have received their green cards or in the process of receiving their green cards and are here on a more permanent basis. Now, it's entirely possible to actually arrive in the U.S. as a green card holder, but from a corporate immigration context, it's much more common for companies to sponsor an individual to come over on a non-immigrant visa to work temporarily, and then to sponsor a green card or immigrant visa once they're here. Now, a second concept is the difference between a visa and status, and there's a lot of misunderstandings about the differences. And a visa stamp is actually placed in the passport by the U.S. consulate or an embassy outside of the U.S. And it's an important document in the sense that essentially in order to get one, you really have to pass a number of background checks. But really, the visa stamp is an entry document, and it's really solely required at the point of entry. What actually gives an individual status and work authorization is something separate, and that is typically secured from the Immigration Service. And usually the way the process usually works is you first have to request the status or work authorization from the Immigration Service, and once the Immigration Service approves that request, then the employee goes and applies for the visa stamp at the U.S. consulate. Once they have the visa stamp, they actually are able to enter the U.S. and they present the officer with their passport, their visa stamp, and proof of their status, or proof of the work authorization that the Immigration Service has provided them. And then they are admitted and issued something called an I-94 record. And this is an innocuous document. It used to actually be a little white card placed in your passport, and now it's actually just a document that you can pull up electronically. But this document is actually what controls the length of an individual's stay. It tells you what classification they're in, and it's actually a much more important document than that visa stamp. Finally, there's a repeated issue of quotas when you talk about immigration, and it comes up in a number of different contexts. There are a number of non-immigrant visas where there's an annual quota, and then there's also quotas that apply to green cards, and you'll hear this issue come up quite a bit in both contexts.
And so before we move on here, Delia, we have our first question from the audience. Jules wanted to know a little bit more about that visa stamp. He's asking, if I have an employee who has an expired visa stamp, is that a problem?
Actually, that is an excellent question, and it's also a very common question, and the answer is it may not be a problem. As long as you have a valid visa stamp when you enter the U.S., you can generally remain in the U.S. with an expired visa stamp as long as that I-94 record shows a valid authorized stay.
Okay, great. Thanks. Okay, so let's focus in on non-immigrant visas here.
Okay. All right. right, so just a refresher again, non-immigrant visas are for individuals who are coming temporarily to the United States. Well, actually I shouldn't say most, some categories, some non-immigrant categories actually require that the employee retain a residence abroad and that the employee intend to return back to their home residence at the end of the stay in the United States. But then there are different non-immigrant visas that allow for green cards, and H's and L's, and we'll talk about those, actually allow you to apply for a green card when you're here. Now there is a visa, a non-immigrant visa, for just about every letter of the alphabet. Not all, up from A to V. And that's why we actually call non-immigrant visas an alphabet soup. The next slide is actually a list of very common non-immigrant visa categories. And I'm not going to go through them all, but what we have done is we want to spend a little bit of time on a couple of the visa categories that are relevant to startups and smaller businesses.
Okay, so it looks like the first one you want to focus in on here are the H-1B specialty occupation workers.
That's right. And the H-1B specialty occupation worker is a visa that's probably the most common work visa. It is for specialty occupation professionals, and that's really defined as an individual who's coming to fill a position that generally requires a degree in the field. So it's really for a professional position. And as part of the H-1B, the employee also has to demonstrate that they have the degree in the relevant field or the equivalent of that degree. In some of these cases, you're obviously going to have individuals from outside of the U.S. and they won't have U.S. degrees. And if they don't have a U.S. degree, we can get an equivalency that says that their foreign education is equivalent to a U.S. education. The H-1B does not depend on a shortage of U.S. workers. So in order to get a non-immigrant visa like the H-1B, you don't have to do a test of the labor market. But there are some issues with the H-1B, and one of the issues is that issue of quotas that comes up. There's only 85,000 available H-1Bs every year, and once those numbers are taken up, that means you can't apply for an H-1B until the next fiscal year. H-1Bs are generally issued in 3-year increments for a total of up to 6 years, but the unique part about the H-1B is that it's the one type of work visa that can be extended beyond the maximum amount of time allotted as long as a green card case is started by a certain period of time. It is the most common visa that's going to work for most startup employees and for employees of small businesses.
So we have a question here from Jana, and she's asking, you know, you're saying it's issued in 3-year increments here, but there's no guarantees with an emerging company, right? The company may not last 3 years. So if it doesn't, what then is your responsibility as an employer to that employee who you've brought over for that 3-year period, and what happens to that now no longer employee?
That is an excellent question, and one of the requirements in sponsoring an H-1B is that if you terminate an employee before the 3-year time runs out or before the expiration of the H-1B, the company has an obligation to actually cover the return costs of transportation back to their home country or their last place of residence. So if for any reason an employee is termed before their H runs out, there's this added obligation of first covering their return transportation home, and then there's actually a second requirement where the company is required to notify the Immigration Service that the termination has occurred as well.
Okay, great, thank you. Okay, so how about the L1A and L1B intra-company transfers?
Okay, this is another visa that startups and small companies can often make use of. And the L1 category is for intra-company transfers. There are two different types of L1s. L1As are for multinational managers and executives, and L1Bs are for specialized knowledge professionals. And this category is really for companies that have a foreign entity, whether the foreign entity is a parent, subsidiary, or even an affiliate. And for eligibility of an individual, it requires that that candidate have worked abroad for the organization in one of those entities at least for a year out of the last 3 years. This category is actually quite nice because it allows spouses to apply for work authorization when they're in the U.S. It, like the H-1B, is initially valid for 3 years, but can be extended for up to 7 years for an L-1A and up to 5 years for an L-1B. What's different about the H-1B is that once you hit your maximum, there isn't a way to extend it. So you either have to get your green card by the time you max out on your H-1B or switch over to another category like the H-1B that would allow you to remain here a bit longer.
And so you're saying this one has a little more flexibility, though? This one doesn't max out?
This one actually does max out, but the flexibility in this one is that it allows a spouse to work.
Okay, understood. Okay, so, sort of shifting gears a little bit, can you talk a little bit about non-immigrant visa challenges that are faced by the startups?
Okay, all right. And this is really the meat of the information today, and probably the most relevant to individuals who are in startups and in smaller companies.
Mm-hmm.
One of the issues that comes up for smaller companies is that the quotas for new H-1Bs has already been exhausted for 2015. In early April, on April 7th, the Immigration Service confirmed that it received 233,000 applications for approximately 85,000 slots. So if you as a startup or a small company want to apply for an H-1B for a new H-1B, and this is for someone who has never held H-1B before, the next time you can apply is April 1st of 2016 for an October 2016 start date. Mm-hmm. This is a problem if you have someone from outside of the U.S. that you want to bring to the U.S. to work for you, and they don't necessarily fit into another category. So another issue that comes up is that the regulations don't really have different requirements based on different company sizes. It's a one-size-fits-all in terms of the regulatory requirements for eligibility for any of these visa categories. But in practice, the Immigration Service does actually scrutinize smaller businesses much more carefully than established businesses and imposes higher evidentiary requirements on the company to prove legitimacy. Now, to a certain extent, this is understandable because they want to make sure that the business is not filing fraudulent applications. But sometimes it feels to us as immigration practitioners that the requests are sometimes burdensome. And an example of when we see the difference between an established company and how the Immigration Service treats new companies, in the same application, we will see that the Immigration Service will ask a smaller company for photographs of the business, the logos, proof that people are actually working in the business, bank account records, invoices showing that you're actually performing work, whereas they wouldn't necessarily request the same level of documentation for a more established company. The Immigration Service also requires proof of a traditional brick-and-mortar establishment, and this can actually be an obstacle for a lot of startup companies, especially if funding is not fully secured, or if you're not necessarily sure of what your headcount is, and you're not ready to enter into a traditional lease. But there are workarounds to this, and one of the things that the Immigration Service has accepted is they have accepted proof that you've entered into some type of an agreement for a shared space or a shared suite. Immigration Service will accept that. But the brick-and-mortar establishment requirement is sometimes an obstacle for smaller companies to file these applications and get them through. A final issue that comes up in the non-immigrant context is that there are a number of non-immigrant visa categories that actually require an employer-employee relationship as part of eligibility. And this has a direct consequence in two different areas. The first is that means that in a number of categories, you can't sponsor a contractor. So you have to sponsor essentially an employee that would receive a salary as well as benefits in the United States. And that can, again, be an issue for smaller companies that don't necessarily have the funding or the ability to make those types of commitments. The second issue that comes up is that when an employer-employee relationship is required, owners and founders may not qualify for those visa categories because they are not seen as having an employer-employee relationship. So that can be a problem, that you can have an owner or founder that can't get a visa that allows work authorization.
Okay, as to be expected, we have a couple of questions here on this slide. First, in terms of that, the brick and mortar business requirement, Alan wants to know if co-working spaces will suffice. So like you're not renting out a suite, but you have a sort of month-to-month lease on a couple of desks in a co-working space. Is that sufficient?
It is usually sufficient. The Immigration Service has typically accepted that. Those are what we call shared spaces, and that's okay. Now, one of the things that's required for the H-1B in particular is that you've got to be able to post a notice internally at that work site for 10 consecutive business days. And as long as you have access to that shared site to be able to post that notice, that's often good enough for the Department of Labor. And then the fact that you've got the agreement with the space manager, the operations manager, that will be sufficient for Immigration Service purposes. So yeah, short answer to that is yeah, that will work.
Okay, great. And then William had a follow-up question about some of this increased scrutiny, and you mentioned some of the things that they might ask to see as proof that you are a real bona fide business. So he's asking, what do you see as the kind of quote-unquote trickiest evidentiary requirement to prove, and then how do you counsel your clients to anticipate and prepare for this increased level of scrutiny?
So the trickiest information is generally with respect to funding and whether the company is able to pay its workers and run its business. And that's often a tricky situation because a lot of small companies don't want to necessarily disclose all of their financial documentation to the immigration. So we do often have to sit down and talk about what we want to provide in advance to the Immigration Service, with the understanding that when you submit something to the Immigration Service, they're typically not going to share that documentation with another agency, and that it's really solely going to be used for immigration purposes. And like I said, they're not going to send some document over to the IRS, for example. Mm-hmm. We do have discussions with companies, and despite this, a lot of companies are often very uncomfortable sharing some of that private information. And what we often do in those instances is, if we think that the case cannot move forward without that basic level of documentation, what we'll do is we'll ask the Immigration Service to consider returning that documentation to us at the end of the case rather than keeping it in their file because of the private nature of the information. And Immigration Service, it's a toss-up. Sometimes they will actually return the documentation. In other cases, they'll just ignore the request.
Right.
But it never hurts to ask.
Right. Right. Okay, great. That's very helpful. And I know a lot of you have other questions, so feel free to keep entering them in, and we'll answer them as they come if we can here. Now we're shifting gears a little bit, though. We've been talking about non-immigrant, and we're going to go to now talk about immigrant visas. So, yeah, I guess we can focus on these 4 roads towards permanent residence.
All right. So we actually call permanent residence the long and winding road. There actually are 4 ways to get to permanent residence, but we're really primarily focused on employment-based permanent residence today. And moving on to the next slide, for employment-based green card cases, and that's what we're talking about. We're talking about how do you get permanent residence, how do you get the lifelong ability to live and work in the United States. And there are primarily 3 ways within the employment-based category that you're going to get green cards. It's first preference, second preference, and third preference. These are the 3 that really apply to most startups and most smaller companies. There actually are 5 different employment-based categories, but 2 of them don't really show up that often. When we say preference category, there are this preference is something that is going to come up when you're looking at quotas. Your place in line is going to be partially determined by what category that you fit into. And the next slide actually kind of goes into what the differences between these preferences are. And the first preference, or EB1, or employment-based first preference category, is for cases where the company does not have to go through a labor market test or a labor certification. These are generally reserved for individuals who have received some type of international or national acclaim in their field, or they could be a multinational manager or executive. These are really kind of people who are at the top of their game. And in some cases, one of the requirements is that they've received some type of noteworthy prize, and the Immigration Service uses the example of if you've won a Nobel Peace Prize or a Nobel Prize, you would be eligible for a first preference case. I always laugh at that.
Yeah, that's all just a Nobel Prize, yeah.
Just a Nobel Prize.
Right.
But these are really the exceptions to the rule. The one notable thing about the first preference category is these are the faster green cards, and they're the fastest way to get a green card. So when someone's eligible for a first preference, it's a great way to get a green card because it is generally faster than the other. The others are the second preference and third preference. These categories generally require a test of the labor market, and second preference is for advanced degree professionals, and third preference is for individuals who are skilled workers or other professionals. These categories do typically take a little bit longer to get through the green card process.
So we have a question here from Joyce. She wants to know if you can elaborate on what a labor market test involves. Is that something that the company can do themselves, or they have to hire someone to do that?
And we're actually going to go through it a little bit, and the labor market test actually does require a certain amount of mandatory recruitment. It's possible to go through this without an attorney, but I have to tell you that when you're going through the green card, you are going to be dealing with different agencies at different points of the process. And some of the interesting part about this is sometimes the rules for if different agencies overlap, and other times they can conflict. And one of the benefits of having an attorney guide you through this is they can tell you when to watch out for these pitfalls. So I guess it's possible to not have an attorney, but I have to tell you, I wouldn't recommend going through this without an attorney. It's a long and arduous process, so the attorneys kind of can really guide you through this and make your life a whole lot easier.
Right. Okay, great. Okay, so can you tell us a little bit more about that permanent residence process then?
Okay, all right. So here, the next slide is really a visual flow chart of what most people go through. The green card process is going to be, for the most part, a three-stage process that starts with the labor certification. That's the application that's filed with the U.S. Department of Labor. Second stage is the immigrant visa petition, which is filed with the Immigration Service. And the third stage is the adjustment of status, and that's also filed with the Immigration Service. There is an alternative to the third stage that can actually be completed at a U.S. consulate. That is not as common as going through the process when you're in the U.S. because the employee can continue to be work authorized and continue without any interruption with employment authorization while they're in the U.S. So it's the adjusting of status, which is a much more common thing to do in the U.S. Now, the next slide actually goes into stage one, which is that labor certification application, or the labor market test. The program that is currently in effect is called PERM, and it's been in effect since March 28th of 2005. So we now have about 10 years of data in terms of what we know that the Department of Labor wants to see. It is an electronic filing with the Department of Labor, and essentially, in order to even file the application, the company has to be able to show that there's a shortage of qualified, willing, and able U.S. workers. And in order to do this, the regulations specify that there are certain types of recruitment that is required, and what has to happen is the company has to actually perform these forms of recruitment, receive all of the resumes in response to the recruitment that's done, and be able to explain why the individuals who have applied are not qualified, willing, or are available. And this is typically the most difficult part of the process, and as I was saying before, it can be hard navigating this, so that's why an attorney who has done many of these is going to be much more helpful than you trying to figure it out on your own. The date that the labor certification or the PERM is filed is actually important because it's really the date that sets an individual's place in line in terms of the green card process, and we're going to talk about the quotas a little bit later on.
Okay. We have a couple of questions here. Some of them I think I'm going to table for right now because I think you're going to get to it as we move forward. But one pertaining to this slide, Malik is wondering if you've already advertised to fill the employee job, do you have to advertise it again for labor certification?
That's an excellent question, and the answer is that it's going to depend. But in order to be able to use advertising for the PERM or labor certification process, the advertising has to be done within 180 days of filing. And also, it has to meet Department of Labor requirements. So for a number of practical reasons, the advertising that you did to fill a slot may not actually be used for labor certification processes. And what the attorney that you're going to be working with will do is recommend that you do new recruitment that meets all of DOL requirements.
Okay, thank you.
Great question.
Okay. So stage two.
Okay, stage two is the I-140 or immigrant visa petition. And whereas stage one is filed with the U.S. Department of Labor, stage two is filed with the Immigration Service. And in short, it's where the company says, look, we were able to show the Department of Labor that we weren't able to find a qualified U.S. worker we actually do have a qualified worker in mind, but this individual happens to be a foreign national. So at stage 2 of the process, the company is going to be presenting the foreign national's qualifications for the job to the Immigration Service. And the company also has to demonstrate that it can pay the offered wage. And this is one of the important parts for smaller companies, because at the time you get to the stage 2 or the I-140, you have to be able to document that you can pay not only this employee's wages, but the Immigration Service will look to make sure that you have enough funds to pay your other employees as well.
Okay.
The final thing is that when you get to stage 2, this is actually when your preference category is determined, and your priority date from the filing of the labor certification is also finalized, and that's also an important concept.
Okay, great. So we know that there's some delays. So can you speak a little bit to the reasons behind some of these visa delays?
Okay, so again, why we call it the long and winding road, and it's emphasis long, emphasis winding, and the basic reasons for that are that there are annual quotas for green cards, and it's a very complex quota system. But what it comes down to is that your place in line is determined by your country of birth, not your current nationality, the preference category, and the priority date. So the combination of these 3 things tells you what your place in line is going to be. And so what ultimately happens is that because of this quota system, certain companies are oversubscribed, and that has led to a backlog of people applying, or it's led to a backlog of people being able to apply for green cards. And so they're kind of stuck waiting for an immigrant visa number to become available to them, and they can't actually get to the final stage of the green card process until this number becomes available to them. It's very frustrating to individuals who were born in India and China, because these individuals usually bear the brunt of the backlog. And the example is let's say you have 2 employees. One's an Indian national and one is a Canadian national, or rather I should clarify that they were born in India and born in Canada. Your Canadian employee might be able to get through the green card process in 1 to 2 years, or your Indian employee may have to wait 10 years or even more because of the backlogs. It's a very uncomfortable and unsettling system that we have right now, and it's all because of the way the quota system works. The Department of State essentially issues a visa bulletin monthly where people can actually track the movement of available green card numbers. And every month we get those numbers and see, oh, it's moved up, it's moved back, or it hasn't changed. But generally, it just means that there's really long waits for certain people.
Wow, I mean, the inequity of that just doesn't sound fair.
Yeah.
You know? But yeah, it's tough. Okay, so moving on to stage 3 then, though, the application for permanent residence.
Okay, so when an immigrant number is available, when a number becomes available and the backlog goes away, then your employee is able to file stage 3 with the Immigration Service. And stage 3 is a little bit different than stage 1 and 2 in that up until you hit stage 3, stage 1 and stage 2 are really applications that are filed by the employer on behalf of the employee. And both stages really belong or are owned by the company. What's different about stage 3 is really the employee's own application. And in most cases, it is where the employee requests an adjustment of their status from somebody who holds a non-immigrant visa. And what they're requesting is an adjustment to becoming a green card holder. For all intents and purposes, stage 3 is really a background check. It's really just to make sure that there's no reason why an employee can't be admitted as a green card holder. At stage 3, employees get to file for work authorization and travel permission, and their family members also get to apply for work authorization and travel permission. As I said before, the majority of individuals who go through employment-based immigration typically go through the adjustment of status process, but there is a parallel process that can take place in the alternative at a U.S. consulate abroad. It just doesn't occur that often anymore because there are some laws that give additional benefits to the adjustment of status that don't apply to the alternative method.
Okay, so just, again, this is kind of the thrust of this presentation. So, what are some of the green card challenges that are faced by startups?
Okay, now, some of the green card challenges mirror the non-immigrant challenges, but there are particular challenges that are specific to green cards, and the actual ownership interest in an organization may ultimately impact the ability to get a green card for founders and owners. And we're going to just briefly touch on that later, but essentially, if an owner or a founder can't be fired or controlled by an independent board of directors or another shareholder, then the Immigration Service really questions whether or not there's a real bona fide job opportunity, or if you're self-sponsoring. And self-sponsoring just is not okay. You have to have a job opportunity that's available. So having a controlling ownership interest can sometimes be a problem. Another common issue is that demonstration of the ability to pay. When you get to the I-140, you have to open your books to the Immigration Service to be able to show that you can pay not only the wage of your foreign national, but that you're a bona fide business again, and that you can pay the wage of your employees. And there are certain required documentation that you have to submit. Generally, if you're a public company, it would be a 10K. A lot of startups, small businesses you would then need to submit your financials, which are typically audited financials, or your tax returns. And sometimes for new companies, those might not be available, and it becomes a scramble to be able to figure out what combination of documents is going to satisfy the Immigration Service, and actually whether or not you have funds that will satisfy the requirement. It can be a problem if you have a startup where your financial numbers are not solid. That can be a common issue. Another issue that does come up is the fact that green cards are location and position specific. So if you are a startup and that your business is in California, and you decide that the cost of business is too expensive in California, and you decide that you want to move to Idaho, for example, that means that your employee, if you were to move your foreign national employee to a new location, a new green card case would be required. And that is a fairly significant cost if you have to restart the labor certification process. And that is something to be taken into account. So things to think about and some challenges that our startups typically face. Now, finally, the question that we often get is whether or not an employee or a company is going to be eligible for the fast-track green cards, and sometimes they're not eligible for the fast-track green card cases, and sometimes it's because the employee does not necessarily meet the high-level threshold required for these EB1 or first preference cases. They may not have the national or international acclaim necessary. On the other hand, it's also possible that the company may not qualify because they don't have an established record of receiving accomplishments in a field or being noted in a field. So one of the challenges is that EB1 eligibility is not as clear for startups and small companies. It often takes a couple of years before an individual might be eligible for a fast-track case.
Mm-hmm. Okay, sorry, moving on here. Okay, so this is something that I know is of interest to our audience, and we have at least one question on this. You know, a lot of people on this call may not yet be considering hiring employees from other countries, but they themselves are from other countries, and they want to understand the considerations for themselves as founders or owners. So I'll sort of let you go through this, and then I'd like to bring in a question that we have from the audience on this.
Sure. Okay. So there are special considerations for founders and owners, and part of it has to do with how the regulations are written. The employer-employee relationship requirement does attach in the non-immigrant visa context in a number of visas, and then on the green card side, there is a little bit of a prejudice against founders and owners when there's a controlling interest, because you have to generally show that there's a real open job available. So that aside, let's start with when is a work visa required? And essentially the U.S. rule is that a work visa is required for any productive employment completed in the U.S. And that means that if you are an owner or a founder, you would need a work visa to perform anything that could be considered productive employment for your company. And so if you have an H-1B for your employer, but you're trying to start a business on the side, you may not have work authorization to actually perform services for your own company. And that's something to keep in mind. As I was saying before, that the controlling interest can impact your eligibility for both non-immigrant and immigrant visas. You have to look at that pretty carefully, again, because more than a 51% interest can kind of be a red flag in both contexts. One of the ways that we deal with this is we counsel our clients when they're thinking about starting a company, how to incorporate, how to set up the business. And we counsel them that the controlling interest can be an impact in their immigration road ahead. And some founders may decide that they actually are going to write into their articles of incorporation that the board of directors has the right of removal, or another individual has right of removal, because it may strengthen the immigration case. There is some good news on the horizon, and that is that President Obama, in his address about immigration executive order, did mention that he plans to enhance options for foreign entrepreneurs. There right now isn't a great visa that provides non-immigrant work authorization for entrepreneurs, and you have to kind of squeeze yourself to fit into other categories. The issue, it's great that he mentioned it, the issue is that we don't yet know how that's going to play out or when that's actually going to be coming. A final note is that an EB-5 employment-based fifth preference investor visa exists for founders and owners that want to invest into the United States. And essentially this is a green card path where if an individual invests either $500,000 or $1 million into a business or a regional center, they can potentially be eligible to get a green card as long as their organization, the one that they invest into, creates jobs. It sounds like a great idea. There are a number of legal loopholes surrounding that particular process, so it's not an easy process to go through, but it is an option for certain individuals. I did want to raise it as a possibility. We're hoping that this executive option might actually also kind of make the EB-5 process a little bit smoother than it is right now.
Mm-hmm. So Bauman from our audience wants to know, is there a possibility of EB2 NIW for a startup solo founder? And if so, can you explain that process a little bit?
It is. National interest waivers do exist, and essentially labor certifications are not necessarily required if you can show that you are working in an area that is of the national interest. The issue, again, is that in the 1990s, there was a case that came down that essentially made this classification very difficult to meet, and national interest waivers just simply were not getting through after that case. We're seeing an opening up of this, and again, this was something that was also mentioned in the executive order, so it is something, it's a category that may open up. The question is, what is work that is in the national interest? And just by virtue of opening a business, that's not necessarily considered by the Immigration Service to be a national interest, but there are certain industries, if you're working in certain industries, where that might be a viable option. And essentially you have to really show that you're doing something that is changing the economy, changing medicine, making a difference in the U.S.
Okay, interesting. Thank you. Well, that brings us to the end of our presentation here. I think we were able to actually get through all the questions as we were going along. So I'm going to pause here for a moment in case anyone has any other questions they'd like to ask now in this forum. If not, you see the contact information up here. So if you have a specific question, feel free to reach out to Delia Ghosh for her to look at your individual case. And if you have any financial questions, if you're in one of those situations, like Delia said, where you have to be pulling together your funding information or your tax or your finances, certainly reach out to us and let us know, and we'd be happy to work with you. So that said, I think we're done here. So again, you'll receive a follow-up email tomorrow that's going to have a link to the deck and the recording. So I know we covered a lot of information, so you may want to go back through and listen in again. We have a bunch of great webinars coming up. We have one on convertible notes and another Ask the VC, where we're going to have Mark Phillips from RFRO Ventures come and take your questions about pitching and pitch decks and how to make a good impression and all those things. So if you're interested, please go to our website and look at our events page for more information about these upcoming webinars and to register. And so, Delia, thanks again. I think this was great. I think you provided so much clarity around what can be really confusing, and I really appreciate you taking the time to speak with us today.
Thank you so much for having me.
Of course. Okay, thanks all. Have a great day. Bye-bye.
Bye-bye.